All right, that was great. Now, if the combatants, I mean discussants, would come up to the front. And I'm pleased that we have DEVEN McGraw here to lead off the discussion. DEVEN is Deputy Director of the Health Information Privacy Office for Civil Rights. And I could have sworn I heard DEVEN say this morning that she was now in favor of sharing all information.
I've actually always been in favor of sharing all information, subject to the conditions set forth in the rules. It's a sharing. It's actually a sharing regime, one could argue, but that is actually a topic of the very brief remarks that I prepared to give. It is actually a little bit hard for me to react substantively to some of the prior presentations on the panel because I'm an expert in data governance, not science, and my biostatistics class is way too far in my past to even opine on some of these issues. But they're important ones, and I know they'll be topic of robust discussion, which I'm very much looking forward to. One of the things that has occurred to me in the many years that I've been working on data governance issues, and HIPAA in particular, but I'm, of course, at least conversationally familiar with the common rule and FDA rules around uses of data and enrollment of individuals in or for research purposes, is that we have an environment where it's perfectly permissible under the regulations for you to do nothing but sit on the data that you're collecting. And in fact, one could make an argument that it is far less risky for you to, in fact, do just that. Collect the data and sit on it. Don't use it for anything other than what you might need for your own purposes. Because frankly, if you decide to dip your toe into the water of using it for public good, for sharing it for research purposes and trying to contribute to the knowledge base, we're going to attach some conditions on that you're going to have to meet. Whether it's through HIPAA regulations where they apply, whether it's through common rule regulations where they apply, and frankly, if you're trying to do something with or contribute data that is perceived to be more sensitive because it's attached to stigmatizing conditions like mental health or substance abuse, we're actually going to make those hurdles higher for you with respect to your use of it. And this is sort of, in some respects, the nature of privacy. It really, and privacy regulation. It really is all about thinking through what are permissible uses and what are the conditions under which we, as part of our responsibility to the individuals who are the subjects of this data, can assure that the uses of it are responsible and respectful of its sensitivity. But even when recognizing that, I do think we need to think long and hard about the fact that when we talk about incentives and disincentives for generation and subsequent use and disclosure of data to generate real-world evidence, that we have, again, made it easier for people to just do nothing. We've put our thumb on the scale in terms of the regulation of this data from a privacy and security standpoint that arguably tilts in favor of doing nothing. It is far more privacy protective now in the way that we have defined the rules to bury the data in the backyard, as long as you've done it securely, than it is, again, to actually make it useful. HIPAA allows for data to be used for a wide range of purposes, and all of the very good examples that we are both aware of and that were spotlighted in these sessions of academic medical centers and other institutions that are moving forward and have formed collaborations around sharing data and contributing robustly to the research enterprise. They need to be applauded again for recognizing that the value of doing that is worth the effort that they need to put in order to assure that they're doing so in compliance with those rules. But we do have, I think, a number of places where there's valuable data being generated and collected, but are not part of the evidence, not part of these conversations around real-world evidence use and generation, and we need them to be ultimately in order to, again, facilitate the environment that we are all interested in facilitating. When we first promulgated HIPAA, what we were concerned about was that, I don't want to say overuse of data, but that people would misuse data, or that we had to be really worried about, oh my gosh, this data is going to be put to so many uses, and we just have to think about how we regulate each and every one of those and make sure that we're allowing the ones that are good and maybe putting some constraints around the ones that might be not necessarily, that aren't bad, but may necessarily be dangerous or raise privacy risks for individuals. And so we created a regime that says you can, but you don't have to. And again, it's all the more sort of contributing to this environment where saying no is perfectly acceptable, except with respect to sharing data with patients, which is another issue. But certainly with respect to, you know, again, uses of data that frankly ought to be routine in an ecosystem where we're expecting to be generating, using, contributing to evidence generation on a regular basis. We don't necessarily have the regulatory environment that creates incentives for that. And I think we ought to think about that. I think the other thing that's worth noting is that some of these regulatory regimes that I've talked about don't apply to all the potential sources for real-world evidence, or even all of the possible entities that might get involved in analyzing data and producing conclusions drawn from it. I mean, certainly with respect to data that's going to be submitted to FDA for a regulated product consideration, you know, those rules are going to apply. Where the common rule applies, it applies, and where HIPAA applies, it applies. But we have a whole potential set of data sources out there, largely in the consumer-facing space, that frankly are generating data on a regular basis, for which there is potentially some very high value from an evidence generation perspective. And yet, frankly, these hurdles that we've placed for some of our institutions who are engaged in real-world evidence collection, curation, generation of hypothesis testing, et cetera, it doesn't apply to them. It's interesting to me to sort of see where's the innovation happening and what impact are our regulations having when their application is somewhat limited. That's actually not an issue that I get to take on myself, because in sitting in the seat of a regulator, my authority is what it is. But it is something I think, as we start to think about what's the ecosystem that we want to see in the future, I think that how we apply whatever are the standards, rules, and regulations, as well as commitments that we're making to the public, that they ought to be more universally applicable as opposed to just for certain entities over others. So now I'm going to step out of my regulator role, because these viewpoints that I'm about to share are my own personally. They are not necessarily reflective of views that might be taken by my agency, but they certainly are. For those of you who I've known for a long time, it's a topic on which I've spoken before. When we think about incentives and we think about the issues I've just raised about unintentionally creating disincentives with the way that we regulate research uses of data, is it possible to sort of rethink our regulatory framework and take the thumb off of one side of the scale and try to put it on the other side of the scale? In other words, to provide some sort of reward or credit for organizations that are doing this the right way, whose policies and practices have been vetted, but who still operate in a regime where they're feeling pretty confident that what they're doing is compliant with the law, but they don't have a blessing from me. They don't necessarily have a blessing from other regulatory bodies. So they're always sort of operating in a risk zone. And for entities who are contemplating whether or not this is something that they should be doing with the data that they're collecting, but they're afraid to jump into the fray because they perceive the regulatory risks to be greater than the potential rewards of doing so. If we can sort of think about a regulatory framework, again, that has a way of valuing behaviors and practices with data that are doing things the right way, whether that's compliance with a set of universally agreed upon standards, whether that's HIPAA, whether that's common rules, some sort of amalgamation of the two, then I think we've got a possibility to turn regulation from something that might in some circumstances operate as a disincentive to potentially operating as an incentive, right? And it's really about reducing the risk of uncertainty from a compliance standpoint and also providing some additional indications of trust, right? I know that if I'm sharing my data in this particular consortium, they've been vetted, certified, they're agreeing to a set of common principles, standards, and I feel comfortable with that, and so I'm going to join. It's just something that's, I think, worth thinking about. It isn't anything that's necessarily on the table that I'm aware of, but I would encourage folks to think about how we put it on the table so that, again, we need something. I mean, Rob started this off by saying, I'm in favor of all data sharing, and I am, but I don't think the answer is we're going to take all the constraints off and everyone just should do what they want to do or they think is right, because I don't think that necessarily contributes to the environment of trust that I think this past day and a half has demonstrated is going to be necessary in order to, again, facilitate the environment we're trying to. Thanks.